extend a warm welcome to all of you joining us for the second phase of Law is Light. This is a series of trilingual legal discussions focused on educating the general public on the laws in our country. Today's discussion focuses on fundamental rights. We will also focus on the duties owed by one individual to another, as it is of equal importance. We have with us today Mr. Thishya Weragoda, a prominent attorney working as an independent counsel at a well-reputed law firm. He counsels clients on matters relating to intellectual property, internet contracting, online privacy, cyber crimes, and confidential information, company law, commercial law, and other practice areas such as constitutional law, fundamental rights, administrative law, and delicт law. He's represented clients as a counsel or a junior counsel before the Supreme Court in a wide range of fundamental rights applications, including the petitioners in Naomi Coleman and Attorney General, and cases on students suspected with HIV, employee discrimination on HIV, the ban on alcohol sales to women, and prevention of corporal punishment in schools. A warm welcome to you, sir. Dulmi Gamarke, our pro bono secretary, will be the moderator for today's discussion. Over to you, Dulmi.
Thank you, Zeenat, and good evening, Thishya. To start
I'm so
off,
sorry, I'm a bit late. I had a family issue to attend to. That's why I got a bit late. I'm so sorry once again.
To start off, my first question would be, what are fundamental rights?
Fundamental rights are essentially a set of rights that are recognized by our Constitution as being basic rights every citizen of this country, and in certain cases, every person who is resident or present in this country are entitled to. If we look at the history of fundamental rights or human rights in Sri Lanka, we are one of the first countries that signed and ratified the Universal Declaration of Human Rights. We've been party to it since 1947. So from the time we did get our independence, we've been party to that convention, where we recognize certain rights as basic human rights. What happened was our Constitution did not recognize them as being rights that are recognized by the local law. So if you look at how Commonwealth countries or common law countries work, international law does not automatically become part of the local laws without enabling legislation being created. So what happened was, although we were a signatory to the Universal Declaration on Human Rights, it was not part of the local law, so to speak. In 1972, when the new Republican Constitution was created, our framers of the Constitution in 1972 included certain rights as fundamental or basic rights. But it did not elaborate as to how those rights can be exercised or how they are justiciable. There's this famous saying that Felix Das Bandaranaike, the drafter of the 1972 Constitution, he was asked, what are these rights and how are we going to implement? He said, I don't think we need to explain it because they can be exercised in as much as any other right is exercised. So in the 1972 Constitution, the idea was that those rights could be exercised in terms of the Civil Procedure Code. Denial of a right, as we well know, Civil Procedure Code recognizes the denial of a right as a justiciable cause of action. So in that sense, the 1972 Constitution recognized that people could go and file action in the district court. Now, what happened was in 1978, when the new Constitution, the second Republican Constitution was drafted, in that fundamental rights were declared to be justiciable in the Supreme Court when it is an executive or administrative action. So that is where we are now. When there is a violation of fundamental right, the right to be free from torture, the right to have the freedom of thought, conscience, and religion. These are rights that are inalienably intrinsic with individuals, irrespective of whether they are citizens or not. Any person who is in Sri Lanka is entitled to those freedoms. Then we also get certain other rights. The right to freedom of expression, the right to be freedom of association, or the freedom to engage in a profession. Certain rights are limited to citizens. So we draw a distinction in fundamental rights itself. Certain rights are universal in nature. My right to think is inalienable, irrespective of what nationality I am. My right not to be tortured or subjected to cruel, inhuman, degrading treatment or punishment is inalienable, irrespective of my nationality. But although I might have those rights, my right of freedom of thought, the freedom to express those thoughts, there are restrictions. That freedom is guaranteed only to citizens. So if we look at the larger scheme of things, fundamental rights are a unique set of rights that are recognized in our Constitution as to being so important, so basic, so fundamental that they're recognized as a separate chapter in our Constitution.
All right. Okay. Thank you for that explanation. So my next question is there a difference between fundamental rights and human rights?
So it's more like, how do you say it? The concept of fundamental rights is within the concept of human rights. So I can't remember the exact word, what you call it in English, but in Sinhala we call it upakulaka. It's within, if you draw a big circle, the big circle is human rights. Within that big circle, there's a smaller circle called fundamental rights. For example, the Universal Declaration recognizes the right of every person to marry another of his or her own choice without any conditions being imposed. Now, that is a human right. But that human right is not explicitly recognized in our Constitution. Another example is the freedom of life, the right to life. Our Constitution doesn't recognize it. But our Constitution says that the life cannot be taken away other than where a competent court says so. So if you look at it, human rights is a larger spectrum in which the fundamental rights that we are talking about consists of a certain element of them.
All right. Okay. It's clear now. And I think you already touched these in your first question. But again, I'd like to ask, can you explain what are the duties or the limitations attached on fundamental rights?
Right. So, like I said earlier, certain rights are inalienable. You can't take them away. Those rights are there because you are a person, not because you are a citizen. For example, the right not to be tortured. So whether you're a foreigner, whether you're a Sri Lankan, whether you're an illegal immigrant, it doesn't matter. You can't be tortured, full stop. Then you get certain rights, like I said, the freedom of expression, freedom of association, freedom to join a trade union, such and such. Those sort of rights, Article 14.1 says, it's reserved for every citizen. The reason being, otherwise what will happen is aliens also can come in and say, oh, I'm entitled to these rights in your country. But no, the right to expression is not something that all aliens should enjoy without limitation. Of course, all citizens also can't exercise the freedom of expression without limitation. I'll speak about that in a little while. But the distinction that I want to draw is very clearly, for example, Article 10 says every person is entitled to freedom of thought. So that is very clear. Every person, Then Article 12 says, no person shall be subjected to torture or cruel, inhuman, degrading treatment or punishment. Again, person. Article 12.1, all persons are equal before the law. So we are saying everybody is equal before the law, whether you're a foreigner, local, it doesn't matter, you're equal before the law. But look at Article 12.2. It says, no citizen shall be discriminated against the grounds of religion, race, language. So that means that foreigners don't exercise that same right. Although every person is equal before the law, it is only citizens who can't be discriminated on grounds of race, religion, language, such and such. Similarly, Article 13 says, no person shall be arrested. So 13.1, 13.2, 13.3, all of it refers to persons. Look at Article 14.1. Every citizen, once again, it comes back to every citizen. So if you look at it, Article 12.2 and 14, the application is restricted to not persons, citizens. So when we say citizens, citizens include corporate bodies also. So limited liability companies are also citizens. And you asked about what these restrictions that we can impose are. So those restrictions to fundamental rights are of twofold. One is what is there in Article 15. Article 15 says which rights can be restricted. Now, the right to be free from arrest and such, if you look at it, Article 15.1 talks about restrictions on Article 13.5 and 13.6. Article 15.2 and 15.7 talk about Article 14.1a, which is very important to us, the freedom of expression. Article 15.2 says, the exercise and operation of fundamental rights declared and recognized by 14.1a shall be subject to restrictions may be prescribed by law in the interest of racial and religious harmony. A very important matter, it says, prescribed by law. So now we will have to look at what law is. We'll park that for the moment. Then the second aspect is Article 7, sub-article 7 of Article 15. The exercise and operation of all the fundamental rights declared and recognized by Article 12, 13.1, 13.2, and 14 shall be subject to restrictions may be prescribed by law in the interest of national security, public order, public health, morality, for purposes of securing due recognition and respect of the rights of freedom of others. For the purposes of this paragraph, law includes regulations made under the law for the time being relating to public security. So if you look at it, Article 15.7 very clearly says, law includes regulations made under the law in relation to public security. Now we need to look at what public security is. So that is there in Article 154. I'm sorry, Article 155. Let me just pick that up, please. The Public Security Ordinance as amended in force immediately prior to the commencement of the Constitution shall be the law enacted by Parliament. The power to make emergency regulations under Public Security Ordinance or the law for the time being in force related to public security shall include the power to make regulations having the legal effect of overriding, amending, suspending, operating provisions of any law except the provisions of the Constitution. So the Constitution in Article 15.7 very clearly says the way to restrict the rights guaranteed under 12.1, 13.1, 13.2, and 14 shall be by law and by regulation under the Public Securities Ordinance. Then the public, and in relation to public security, the Constitution says the power to make emergency regulations and the public security ordinance can have the power of overriding any law except the provisions of the Constitution. Now, the Constitution also has a very interesting provision in Article 160. Hang on, let me just find that. In Article 170. Law means any act of parliament and any law enacted by any legislature at any time prior to the commencement of the Constitution and includes orders in council. So it's very clear, laws are only acts of parliament or orders in council. So for example, hypothetically, if the Minister of Health today publishes a gazette saying that with effect from the 1st of April, nobody can enter into a public place without vaccination, that is not law. Because the Constitution very clearly says what a law is. And the rights guaranteed under Article 14.1, freedom of movement of citizens, cannot be restricted unless it is made, regulation made under the emergency law or by an act of parliament. There's nothing else. The minister can't do that. So hypothetically, if the Minister of Health decides to do that, that would be obviously ultra vires of the Constitution, unconstitutional. There is no legality of it. But let's say that the president invoking the emergency regulations comes up with it. Now we can see that sort of thing happening in Canada. If the president invokes emergency and does it, then in terms of 15.7, that becomes law. So those are how restrictions apply to the exercise of fundamental rights.
All right. Thank you for that detailed explanation. And also, I think the examples you got, like they were current examples and very important. My next question is, this also we have touched upon a bit, but we would like to know in detail, how can we explain freedom of thought and restrictions based upon freedom of thought specifically?
Like I said earlier, if we look at Article 15.7, Article 15 itself, there are no restrictions that are placed in relation to Article 10 and Article 11. You can't tell someone, don't think. The police, the CID, all the king's horses and all the king's men can't come and say, don't think. They could possibly say, don't talk. But they can't say, don't think. That's a very important distinction. We are entitled to think of anything. And our thought, by saying thought is not limited to what is inside our head. For example, it is a thought in the sense, when I decide whom I marry, that is an exercise of the freedom of thought and my conscience. I choose who I marry. So, for example, the Registrar General of Sri Lanka cannot say, oh, you need a permit if you want to get married to a foreigner. Because it is my thought and my conscience that wants me to marry someone. So, Article 10 very clearly says, no, the state can't interfere in that. Not just the state, any person can't interfere in that. But if the state does, you can come to court. There's this very interesting case called Stanley versus Georgia, a US case in the late 60s. There was a man who had certain pornographic material in his personal possession. kept for his personal consumption. Not for sale, not for distribution, but for his private consumption. His house was raided and he was prosecuted under the laws of Georgia. The Supreme Court very clearly says it is not the state's job to tell people what to think. It may be the state's job to say, what you are going to say, I'm going to curtail. But the state doesn't have any right to say what you think is against the law. I wonder whether you all have heard of this movie called Minority Report. Possibly a movie from my generation, not yours. They had a concept called pre-crime. It's a very interesting movie. There were three, what do you call them, oracles. So they could foresee murders being committed. And before the murder is committed, they would alert the police and the police would go and arrest the person for a pre-crime. What you call a pre-crime. So no deaths in that city. We don't live in that utopia. If you think you want to kill someone and you keep it in your head, that's only premeditation. Mens rea only. There is no actus reus so long as it's still in your head. If you do it, then your premeditation comes into fruition and you're committing an offense. So the police can't say, no, you can't think of killing someone. You can't in your mind fantasize about a certain person. You can't say that. There's no offense. You can't control that. So that is the freedom of thought and the freedom of conscience.
All right. Okay. Thank you for that. And moving on, my next question would be, what does equal protection by the law mean?
So equal protection by the law generally means that equals are treated equally. It does not mean that everybody is equal at all circumstances. If you look at the history of our law and the development, in the late 80s, there was this case called Elmo Pereira versus Montegu Jayavikrama, 1986, 1 SLR, if I remember right. In that, what happened was, Elmo Pereira was the Surveyor General at the time, or Deputy Surveyor General, or someone. Montegu Jayavikram was the Minister of Public Administration. Elmo Pereira was also the President of the Tennis Association or something. One day when Montegu Jayavikram came to play tennis, basically Elmo didn't allow Montegu Jayavikram to play tennis or something like that. There was a little bit of a feud. Next day, the minister came and kicked this guy out. So he filed a fundamental rights case. Then the Supreme Court said, look, for there to be discrimination, there has to be someone who is positively treated as opposed to a negative treatment. So in effect, the Supreme Court took a very, very narrow view that for there to be discrimination, there has to be one person who is treated better than you. And here, Elmo was just kicked out. So there was no discrimination. Of course, the Supreme Court later on went on to correct that position. Somebody versus Lienege versus University of California or something was the first case. Somewhere in the late 80s, the Supreme Court said that no, there is no requirement that somebody has to be positively treated so that the other person is negatively treated. If the yardsticks of the law are not met, that is discrimination. If the law is not followed, if due process is not followed, that is discrimination. So as of now, what is meant by equal protection of the law is that if the due process, if the principles of natural justice are not followed, if, for example, let's say an exam, there are 50 vacancies and there are 100 people who are applying. Either you must say that X to A to whatever, 1 to 100, these are the people who have gotten in and these are their marks. Or you must say this is the cutoff and these are the people who have gotten. So either way, there must be certainty. So when there is a lack of certainty, the Supreme Court views that as discriminatory in certain times. We must also remember, like I said, the law does not always expect everyone to be treated equally. The law expects people who are similarly circumstanced to be treated similarly. The famous judgment of Ramapulli versus Festus Pereira, that is the case where the Supreme Court recognized the principle of reasonable classification. So, for example, at the advanced level examination, students who write for a particular syllabus, let's say the old syllabus, and the students who write under the new syllabus, they shouldn't be matched together. They should be assessed according to their own syllabus. That's called a reasonable classification. So the law of equality doesn't mean at all times everyone is equal. It looks at whether similarly circumstanced people have been treated differently also.
All right. Okay. So my next question would be, what is the right to information?
Right. The right to information is a new right that we recognized after the 2015 amendment to the Constitution. Now, this right was a right that we claimed for a very long time. And it was a long time coming. Even before the right to information was recognized as a fundamental right, Justice Mark Fernando, in the famous SLBC case, said that the right to expression also means that for someone to express, there must be someone to receive it. So there is a right, implicit right to right recognized by our Constitution, in the sense that it is a necessary correlation of the right of expression that someone else receives it. So therefore, the Supreme Court sort of recognized that there is a right to receive information. It did not mean that you could always write to a public authority and ask for documents, but it recognized that there was a right to receive information also. And in 2015, after the constitutional amendment, Article 14A recognized the right of information, right to receive information. Now, in this right to receive information, it's very important that we understand certain aspects. Sorry. Now, in fact, when this right to information was, the constitutional amendment was made, there was a little doubt, because in one sense, there was this argument that there is an Official Secrets Act, which says that public secrets cannot be divulged, such and such. So, in the sense, there was this issue of the state sector was worried that there will be an inundation of information requests, such and such. But at the end of the day, sanity prevailed and Article 14A came into fruition. So if you look at it, every citizen shall have the right to access any information provided for by law, being information that is required for the exercise and protection of the citizen's right held by any state, the state, ministry, government, department, such and such, a minister, any local authority, any person who is in possession of such information relating to such institute that is there in A, B, or C. And then, like Article 15.7, Article 15, 14.2 said no restriction shall be placed on the right declared and recognized other than by such restrictions prescribed by law as necessary in a democratic society, and then sets out certain restrictions. So, in line with this, Act number 12 of 2016 came into being. Now, according to those provisions, people can make applications for information that is held by public authorities. You make the request to what is called the designated officer. They have 14 days to respond. If you are not satisfied with the response, within 14 days, you appeal to the authorized officer. authorized officer must within 14 days give a response. Within 28 days thereof, you can appeal to the Right to Information Commission. So that is how the right to information works. This is a very important aspect in good governance. The public will become aware of the workings of the government only when government information is accessible. So that is what the Right to Information Bill does.
Thank you so much for that explanation. I also feel like that was a long-awaited explanation for the general public. So moving on, we'll be focusing on the remedies available for breach of FR from here on. My next question is, what do you need to do in occasion of breach of your fundamental rights?
So one of the first things that you can do is to lodge a complaint with the police. For example, if it is a matter of torture, you can try to lodge an entry with the police if the police is forthcoming to accept your complaint. Secondly, if you have physical injuries or trauma, you could admit yourself to a hospital. Thirdly, you could complain to the Human Rights Commission. And fourthly, you could file an action before the Supreme Court for the violation of your fundamental rights. Of course, this is in addition to your ordinary right to file a damages action before the district court for any injuries that you have sustained. So if you are to go to the Supreme Court, Article 126(2) of the Constitution says that such application must be made within 1 month of the infringement. So in the case of Gamatige versus Siriwardana, the Supreme Court held that 1 month means 1 month from the date of knowledge. Otherwise, what would happen is I might get tortured by the police and kept in police custody for another 2 weeks without access to justice. And then say that, no, you got beaten up on such and such a day, your application is out of time. So to prevent that, the Supreme Court says it's 30 days or 1 month from the date on which you become aware of the violation of your rights. So that is how it works. Of course, if you go to the Human Rights Commission within that 1 month period of time and lodge a complaint, and your complaint is bona fide. If you say that I'm going to file this complaint to the Human Rights Commission so that I can buy more time to go to the Supreme Court, that is not bona fide. But if you do it bona fide, you go and lodge the complaint to the Human Rights Commission because you don't have information. You don't know the assailants. You don't have the necessary documents. You go and lodge an entry with the Human Rights Commission. Sorry. And in that inquiry, you find more material. If you so desire, while that application is pending, you can go before the Supreme Court, despite you being several months away from that 1 month period. Because the Act, the Human Rights Commission Act very specifically says the time period during which the application is pending before the Human Rights Commission is not considered in calculating the prescriptive period in Article 126.
All right. Okay. Since we also touched upon torture when answering that question, my next question would be, is it only limited to physical torture, or how is torture defined when filing for a breach of fundamental rights case?
No, certainly not. Time and again, our Supreme Court has held that mental torture is also considered as part of torture. But the threshold is higher because it's very difficult to establish mental torture. If you look at the case of WMK De Silva versus Chairman Fertilizer Corporation, that is what Justice Amarasinghe says, that there is a higher degree to establish. Then there was a recent judgment by Justice Eva Vanasundara, where she held that mental psychological trauma will remain despite the physical scars going away. And that it is important for court to recognize that such trauma might remain. And the same principle was considered by Justice Buonekalu Vihare in Bogavatta's case. I can't remember the name, where a young girl was taken into police custody and kept on the basis of some random allegation which was not true. A school-going child. The Supreme Court Justice Alvihare held that psychological suffering is also an aspect that has to be considered.
All right. Thank you. My next question would be, against whom can I file petitions on breach of fundamental rights?
So essentially, Article 17 of the Constitution says that action can be filed only in the Supreme Court by way of a fundamental rights application only against executive and administrative action. So which means that you have to either be in an executive position or in the executive or an administrative position. So this also means that come entities in the nature of Sri Lankan Airlines, Sri Lanka Insurance, which are private entities but held by the government, the Supreme Court has held that they are also machinery of the state. So it's not just the government corporations and its employees, it's also private companies and such that are held by the government. Then the second aspect is, I think Robinson Hotel case, Sri Lanka Insurance case, there's some Sri Lankan Airlines cases also that have held them. Then the second aspect is, what about individuals? There's this famous case, Fies versus Attorney General. Justice Mark Panando held that when a police officer did nothing, when a member of parliament came and sat in the OIC's chair in Polonnaruwa and harassed a forest officer for doing his job, and when he was assaulted and the police officer did nothing, that omission, the failure to protect in favor of a member of parliament, even the member of parliament was part of that entire transaction, therefore he's liable. So we see this sort of problem every day. We see the police or certain other state institutions to support another private individual doing certain things. In such situations, the Supreme Court at times have held that the private individuals are also liable to pay compensation. A very good example is Vasudeva Nanayakkara versus Chandrika Bandaranayak Kumaratunga, the famous Water's Edge case. There, the Supreme Court held that the former president and certain other individuals had acted in a manner to benefit the Water's Edge investment, and that the former president is liable to pay personally. The investor was also liable to pay personally to the state. So you get that sort of judgments also. Then you also get the situation where who can be made responsible. The question also comes as to whether what is the responsibility of the state for conduct of individuals. For example, if a school teacher or a police officer assaults a student or a citizen and there is injury, who should bear the damages? Is it the state that should pay the cost or damages or compensation, or should it be the individual? So the recent trend has been that the individual will also have to be held responsible and pay out of pocket, but the state also, to set an example, will have to bear a cost. So in effect, what happens is that at the end of the day, some errant public servant will go and hit someone, and you and I all included, from the various taxes that we pay, we have to compensate to our fellow citizens. I personally think that such costs, the state should file action against that officer and recover it in a separate action. But unfortunately, we will never see that, because the state or those in power wouldn't want themselves being held accountable in any manner.
Thank you for that lengthy explanation, sir. So my final question for today's session would be, can someone file a petition of breach of fundamental rights on behalf of a third party?
Most certainly, yes. But in only certain circumstances. The first is that the Supreme... Okay, let me give a bit of history first. In the late 1980s, there was an insurgency. And there were hordes of people who were carried away and kept in incarceration without trial, without following any procedure. So there were a bunch of detainees in the Boos Navy camp who wrote a letter to the Honorable Chief Justice saying that we are being kept against our wishes, we are not being produced before a court, please help us. So the Supreme Court ex mare moto took up this matter and heard the matter. It's a famous case called the Boos detainees case, and the court granted certain relief. And then the Supreme Court realized that, okay, this is a serious problem. The Constitution only recognized the person whose rights are infringed to come before court. So it's very easy to take the person and keep him in custody, and now he can't file a case. I mean, it's a very simple way of circumventing the law. So then the Supreme Court in 1990 drafted a set of rules called the Supreme Court rules. And in the Supreme Court rules, it said that an attorney at law on behalf of a person can file an application without that person being made part. So now that is being made use of quite often by lawyers when their clients are abducted. An attorney at law without a proxy can go and file an affidavit and move that the matter be taken up. In fact, there are several cases that even I am doing where we have done that. There are so many cases that on day in, day out, we see such cases. In fact, recently, when in a case where we wanted to protect the privacy of the petitioner, the application was filed on behalf of that petitioner by an attorney at law, with the petitioner, the aggrieved party's name being just mentioned as Citizen X. The Supreme Court recognized that application. So you see, for a disclosed person, an attorney at law can appeal. Also, there is another exemption. If you look at Shriyani Silva versus Iddamal Goda, the Supreme Court held that when a person dies in police custody and your complaint is the death, the wrongful death that was caused, then such matter, the next of kin can file application. Otherwise, what would happen is, if the police wants to torture someone, they are better off killing the person than letting the person live, because if he lives, he can come and file an FR application. If he's dead, he can't file the FR application. So to prevent that abuse, the Supreme Court said in Shriyani Silva, yes, you can ask the wife or the next of kin to come and file an application. So these are the exemptions that are now prevailing.
All right. Thank you so much for the valuable insights, sir. Next, I'd like to hand it over to President Seenath for the question and answer session.
Thank you, Dulmini. So we sent out a Google form prior to discussion to invite the public to send us a couple of questions. And one of the questions is, can you explain the right to privacy?
The right to privacy is not a right that is explicitly recognized in our Constitution. Of course, the Digital Data Protection Act is almost now there. We've already, it's before Parliament now. So there'll be some sort of protection that you get. But we do have a right to privacy in our common law, the Roman Dutch law, where there is an expectation of privacy there is the right to privacy. But it is not a right that is recognized by our constitution.
Okay, sir. Sir, so far we've spoken on rights. Could you also speak on the duties that come with the rights? Because I believe the rights and duties are complementary. And if you can speak on duties as well.
So, in the sense of the duties of the citizen, is it?
Yes, sir.
So, in the sense, the obligation on the citizen is possibly not to abuse the right. But of course, at the same time, the right is more often abused by the executive. So the obligation, I would say, is not on the citizen per se, but on the state to ensure that those rights are respected. For example, if I criticize the government today, the government shouldn't necessarily come and arrest me under section 120 of the penal code, because section 120 of the penal code itself recognizes my freedom of expression. So the obligation is mostly on the state. And one thing I forgot to mention earlier when discussing with Dulmini was that Justice Amarasinghe in Sunila Abesekara versus Arya Rupasinghe very clearly says that any restriction imposed on the exercise of a fundamental right must be given the narrowest of interpretations, not the broadest. So the right has to be broadly interpreted and the restriction must be narrowly interpreted. So that is the important aspect.
Is there a rationale behind why it should be narrowly interpreted?
Because in a democratic society, the right of the citizens is paramount. It is not the right of the state to restrict freedoms paramount. So if the state wants to restrict us, those restrictions must be as narrow and precise as possible. That is how rights are to be recognized.
Okay, thank you, sir. There's one last question. Is legitimate expectation considered a fundamental right?
Legitimate expectation does fall within the rights recognized in the right to equality. So if the state has in fact made a representation to me and I have acted upon it, and the state is now attempting to rescind from it without a reasonable ground in order to favor another or maybe not, then that would be a ground of violation of Article 12.1. Like I said, due process, natural justice, all of those concepts fall within, all those concepts, irrationality, disproportionality, all those concepts that we discuss in administrative law also do fall within the concept of Article 12.
Thank you very much, sir. Now I invite Dulmini to present the vote of thanks.
Thank you, Zeenath. Thank you, Mr. Thishya Weragoda, for taking time off your busy schedule and joining with us today for an insightful session. Thank you, everyone who joined us virtually. Before concluding today's proceedings, I would also like to thank our sponsors, Scholars Guide and Prudential Shipping Private Limited, for your valuable cooperation. Thank you once again, everyone, for joining, and stay tuned for our next webinar. Good night.